and A2, where they were seeking a constitutional reference to the Constitutional Court. My Lord, it is a submission that before any court refers any matter for constitutional reference, it must be satisfied that there is a question of law, that there is a question of law right for interpretation. Any matter that is guised under interpretation, but the actual sense of it is a violation of a human right, is not a matter that this court can refer for interpretation. This court has been extremely fair to the applicants right from the start to date. The premise of the application is the alleged complaint to the Judicial Service Commission. My Lord, there is no copy of that complaint. But even if there was a copy of that complaint, still, if there is a if that a complaint really exists, then it is the duty of the Judicial Service Commission to serve the same to the judicial officer and in fact determine it. Mhm. My Lord, that letter has not been brought, or complaint has not been brought to the attention of the prosecution. My Lord, there is no act of the judicial officer so far that so there is no act, my Lord, of the judicial officer so far that requires constitutional interpretation. Mm. My Lord, our senior colleagues are aware that they have an option of filing an application of that nature before the Constitutional Court. That petition, yes. Thank you, Senior Counsel. But as far as we know, the facts, my Lord, as they are, there is nothing worth interpreting. My Lord, we shall furnish you with the authority of Serugo Ismail versus Kampala City Council and Attorney General, in which it was stated that there must be a question of law. Otherwise, the Constitutional Court would be flooded with references. Which references, my Lord, in most cases, just like in the current matter, are intended to frustrate the process. So, my Lord, it is our submission that this court agrees with the prosecution that there is nothing to interpret and therefore to refer. And as such, dismiss this application, my Lord. If it were a civil matter, it would be great to have it dismissed with causes. So,
The role of a prosecutor in a court of law is to lay the judges and present all the evidence to the court for the court's evaluation, and to at all times uphold justice so that even if there is favorable evidence that is favorable to the accused, a prosecutor ought to be able to present it to the court. Therefore, a prosecutor is not a persecutor. A prosecutor should restrict themselves to ensuring that the process is fair to all the parties, including the accused person. Therefore, very surprising. Here, a learned human oppose and to oppose an application for the interpretation of the Constitution on the right to fair trial. prosecution, just like the defense, has no role in the interpretation of the Constitution. That's the preserve of the Constitutional Court. I would urge the court in this regard. The gratuitous intervention of the prosecutor and restrict itself the need for the interpretation of the Constitution as to whether, just as put clearly by my colleague, the right to fair trial has been breached by the circumstances before the court, mainly that A1 and A2 have a petition, have your lordship, and I once said justice is about needs not only to be done, but to be seen to be done. It's that judges are human, you are human, my lord, and the perception of the man of the state. We let be that justice can be obtained in this court or right to bear trial has been obtained. Mine was just to comment on the prosecution. I see.
My colleague from the state, because he did not object to the fact that what we are asking for comes out of a mandatory provision of the Constitution, namely 137(5)(b). My Lord, I take it that we are in agreement with the text of the Constitution, where a party seeks a reference, the court shall refer. So I'm really grateful for that concession. The text is clear. Council is comfortable with our interpretation. My Lord, to the view that court must be satisfied that a question of law has arisen, Lord, we did propose the question. It is a question of law. And again, my learned friend has not objected to that question, or that it is a question. My Lord, the trial before an impartial tribunal, or indeed one which may appear not to be impartial, is a serious, fundamental question of constitutional interpretation. If my Lord does what Article 137(5)(b) requires, my Lord does what Article 137(5)(b) requires him to do, the Constitutional Court will, among other things, tell us what constitutes an independent and impartial court for purposes of Article 28(1). So we submit that there is a matter ripe, to use the words of my learned friend, ripe for interpretation. My Lord, the state has responded about the complaint before the Judicial Service Commission. And is a bit unhappy that it hasn't been served on them. My Lord, the complaint is not against the prosecutor. Otherwise, complainants would also be acting against Article 28, but they are not. They cannot even deny its existence because the ruling of the court confirmed that indeed it exists. And the officers that are authorized to deal with it are dealing with it. The attempt by the state to go against your Lordship's ruling this morning will not be allowed to go unchallenged. My Lord, to the point that our clients can file a petition directly for the Constitutional Court, that is indeed true. Not just to our clients, but to any other person. And however, Constitution also provided, because that is in Article 137(1), Constitution also provided avenues, other avenues in 137(5). My Lord, the distinguishing factor is that the question for interpretation of the Constitution arises in proceedings like this one. So, one 137(1) is available, so is 137(5). 137.1 does not use the words shall in addressing the court as 137.5 does. And my lord, lastly on that point, there is no bar at all to the party choosing the most expedient avenue therefore where proceedings are going on like this 137.5 B is the most expedient option. The prosecution may not like it, may be unhappy with it, but it's the constitution. So my lord, the before I sit down, the matter that has been raised today, my lord, is not about determination of the complaint before the JSC. It is related, but the specific problem, my lord, I say this with the utmost humility, is whether a judge who is a respondent in a complaint before the JSC can try, sit in a matter to determine the innocence of the persons complaining against that judge. The unfortunate question we have to deal with. And it is my humble request, humble prayer, that you accept to refer question that, my lord, we spend the next few minutes refining that question if it is required. The state has made no contribution to the raising of the question. So now, my lord, between the court, those seeking question, we refine it if need be. Otherwise, prayer is that it be referred in the format that it was presented to the Lordship. Very, very humbly.
So with that scenario, my Lord, an independent observer, a fair-minded, reasonable person would definitely conclude that one cannot be impartial. The reason, my Lord, the proceedings of this nature are structured in such a way that the assessors, these ones, they are not lawyers, they are laymen. These three assessors here. They are ordinary people picked from downtown. So how do they perceive that situation, my Lord? That's what is enlisted under the law. That will you be fair and just in deciding the fate of the accused persons when actually they are putting it? Yes, my Lord, that's where I'm headed. That's where I'm headed, my Lord. This is the matter again. My Lord, that reinforces my submission. Yeah, that reinforces my submission. These are the real issues, my Lord. My Lord, that is the spirit and the letter of Article 28. Article 28 of the Constitution. Read it together with the Article 44, which is a non-violable right. This is the issue to be now interpreted by the Constitution of my Lord. Whether indeed there is a likelihood of bias on your part under the circumstances. This is a matter to be interpreted. Not that actually you are biased. Let's distinguish the two. Not that you have demonstrated actual bias, but is there a likelihood of bias on your part under the circumstances? That's the point that was made, and the point I'm emphasizing. And this is what is stated under Article 28 when the Constitution talks about an impartial judge or court about perception. That's the point I was emphasizing. And that cannot be determined by this honorable court, because that's what the state was seeking, that you pronounce yourself on this matter, that whether there will be a likelihood of bias or not. It's not up to my God now to sit in your own matter. My Lord, it's our prayer that you put all these matters in consideration and what the matter the Constitution of God. The issue as to whether this court has received, or actually the state has received, a copy of the complaint or not, has been substantially addressed and answered by Council Kalibara. But I'll add one thing, my Lord. Some record, my Lord, in the course of the hearing this month, when the matter was being raised by A1 himself, attempts were made to supply you with a copy of the copy. The accused person, Dr. Besigye, volunteered to submit his own copy. And the court said no. What he declared as no. Please retain your copy. Their mechanisms. What will use to get its own copy. The state was interested in it, but it was available. But they never expressed interest in it. So we retained the copy. But the fact is, my lord, what is not in dispute is that there is a complaint before the Judicial Service Commission. I mean, the Judicial Service Commission. It's not in dispute. And indeed, from the record, what indicated that that matter is in existence. What is aware of the existence of it. It's no longer in it's not in dispute. Finally, my lord, the option is talking about we have to file a substantive petition. Cannot be used as a bar. This court to invoke its powers to refer this question. In the wisdom of the CA promulgated the Constitution under Article 137. Options were considered to be necessary to be enshrined in the Constitution. So all these imperatives were put into consideration when they were promulgated the Constitution. Under which circumstances you invoke which particular provision. In this particular case, clause 5 of Act 137, it was appropriate when a matter has arisen in the course of the proceeding. So you do. You ask your father judgment to file a petition? No. The reasonable thing to do under those circumstances is to prove the trial judge. What that question for consideration by the court, which we are doing. So we reiterate our prayer. I will do so.
And that won't take me more than 6 minutes. Just want to respond to what I feel my colleagues did not address. Lord Mr. Billy Vumbuka for the state submitted that not every matter which is a violation of a human right amounts to a referral. The Constitution, the Constitutional Court for interpretation. Not the proceedings before you currently are not for human rights enforcement. Not as you rightly pointed out to my senior colleague, issue is about a reference for interpretation. And whether a matter has arisen in the proceedings before you, before your lordship today. Lord, for the accused persons, we submit that it has arisen. How, my Lord? In the ruling delivered by the court, the court pronounced itself thus: that the existence of a complaint in the JSC against a judge is not a bar to prosecution. My Lord, that's a general principle, because indeed a complaint may arise brought by A and yet the judicial officer is presiding over a matter against B. The issue here, my Lord, is that the court would be sitting in a matter where the complainants before the JSC are the accused persons before the court against which they complain. So that, my Lord, the issue before this court is whether the court can sit in a matter determining the innocence of individuals who are complaining against that same court. Yes. Yes. My Lord, same point, and we are saying that that question is to be judged or is to be tested in the realm of Article 28(1) and 44. That's the issue. It's not about bias, it's about the question of a fair trial within the ambit of Article 28. Lord, that's the point for interpretation. We wish to rest our case.
Today's date was for ruling. You remember last time we made an application for the judge to recuse himself, and actually the application was started by Dr. Besigye himself. We only came in to support the legal arguments. Today, Justice Baguma has dismissed the application. We are obviously not satisfied with the reasons he gave, noting that our main reason for asking him to disqualify is that both Dr. Besigye and Obed Lutale have made an application to the Judicial Service Commission asking for Justice Baguma to be removed as a judge. We are therefore saying in those circumstances, he cannot do justice to the case. And even if he did, nobody would believe that he was impartial. So our clients have instructed us to ask the court to refer the matter to the Constitutional Court. And that has just been done. That's what we have concluded doing, telling Justice Baguma to refer this matter to the Constitutional Court for interpretation, whether the set of facts, mainly the fact that Dr. Besigye and Lutale have accused him before the Judicial Service Commission and ask for his removal, whether insisting on hearing their matter constitutes denying him the right to a fair trial. Remember, he is human like you and me. So that is the matter now he will give a ruling on the 6th of November. So we'll be coming back to court on the 6th of November at 11 for him to tell us whether he is going to accede to our request to have the matter referred to the Constitutional Court for interpretation. Over to my colleague.
Mu Luganda mukimanyi bulungi tumaze ebbanga ddene ekigenda kwera myezi 5 nga tulwanagana ne Baguma ave mu musango. Emyezi kigenda kwera 5 nga tugamba mwami Baguma Emmanuel ave mu musango guno olw'okubanga teyeetengeredde ate n'entaputa y'amateeka ya munguuba n'alemeramu olwasembyeyo Dr. Besigye kennyini n'asaba ye amwegambire yasookera Ghana n'amugaa atajja mukkiriza kwogera naye oluvannyuma bwe yamukkiriza Dr. Besigye n'amugamba ssebo nakutwala mu Judicial Service Commission nga nkwemulugunyaako olw'okuba nekyekubira mu musango guno guveemu okuwa omulamuzi omulala. Ekyokubiri fayiro eno yali inagenda mu ICD eri mu International Crimes Division naye gwe n'ogiremerako yajja etya wano va mu musango guno nfune omulamuzi omulala. Olwaleero Baguma era awadde rulingi ng'alemeramu. Ekisooka kitwebuuza Baguma yalaba ki mu fayiro eno omutakwagala kumuwozesa ekintu ekyobuvunaanyizibwa omuntu kyalina okukola naga nti kale kanguviimu naye omulaba agulemeddemu ate nno n'obusungu bungi mumulaba kwate jagukwatamu n'obusungu bungi. Kati kyetuvudde tugamba nti owaayi ensonga zino katuzongereyo mu Constitutional Court tumusabye nti ssebo amateeka galaga ekituyise perception nti public ye n'ekiraba etya era emisango mugiwulidde gyonna givuddeyo nga giga nti abalamuzi kasita bakwemulugunyaako kyoteekeddwa okutunuulira nti singa nnemera mu musango guno yo public eneekiraba etya nti ddala mbadde mwenkanya oba sibadde mwenkanya. Kati atugambye ajja kuwa rulingi ye ng'ennaku z'omwezi 6 omwezi ogujja oba ddala fayiro anagiweereza mu kkooti etaputa ssemateeka oba taagiweerezeeyo. Naye ng'ekyera kikulaga nti alina ensonga kubanga n'olwaleero yali badde asobola okuwa rulingi tiwuli kimulemesa. Olwaleero ziri ennaku z'omwezi 15 wibuuze okutuuka nga 6 okusalawo oba ddala anaaba mwenkanya oba taabe mwenkanya mu musango kimwetaagisa mwezi mulamba okusalawo ekyo. So kino kikulaga nti ddala omusango guno aguyinamu personal interest. Kyetulwanyisa kuba tetujja kufuna bwenkanya wa mwami Baguma twagala genda mu kkooti etaputa ssemateeka era tulemeddeko tujja genda mu kkooti etaputa ssemateeka.